we are going to move on to another speaker who I don't think is going to make me cry, but I can never tell. Every year I get up here hoping not to cry. Now I get to introduce my friend and colleague, Ben Mathews. And Ben, I am sorry that you are following that, but there is nothing I can do about that. Ooh-wee. Dr. Mathews is a professor in the School of Law at Queensland University of Technology in Brisbane, Australia, where he leads the Childhood Adversity Research Program. He's also adjunct professor in our Department of Mental Health here at the School of Public Health. All right, who's got a tissue for me? I'm crying, my nose is running, I need a tissue. Somebody out there has a tissue in their pocket. There we go. Oh. Okay. That was a Boy Scout because they're always prepared. It's a silk handkerchief that I think is mine now. Yeah, thank you. Oh my God. All right. Professor Mathews' research expertise is in the prevention, detection, and response to child sexual abuse and neglect by legal and social systems within a framework of law, public health, and children's rights. His specific interests include child sexual abuse, institutional liability, statutes of limitation, and mandatory reporting laws. His multidisciplinary and empirical research centers on analysis of the impact of law and policy, education, and skill development in lived experience, and the study of law and policy as an agent of change. Professor Mathews has advised multiple governments on law reform. He was a professorial fellow to the Australian Royal Commission into institutional responses to child sexual abuse. He served on the World Health Organization's Guideline Development Group on health sector responses to child sexual abuse. And he served on the World Health Organization's Guideline Development Group on responding to child and adolescent sexual abuse. That's where Ben and I met. I am very pleased to say that he's collaborating with the Moore Center on a project funded by Bloomberg Philanthropies that I'll describe later today, but that also focuses on preventing child sexual abuse in institutional settings. Won't you please join me in welcoming Professor Ben Mathews to the stage. Sorry, that was a little disjointed. Thanks, Ben.
Thank you, Elizabeth, and thank you to the Moore Center, and thank you to the other speakers and Representative Wilson. It's a privilege to be here today. I've travelled quite a long way, but I would do it all over again 10 times to have the chance to share in this occasion. I first became involved in this field in 2001 when a few people told me that they had had experiences of child sexual abuse and that they had been prevented from taking civil legal action in the courts to seek compensation for their injuries because they had been blocked by a combination of the statute of limitations and institutions' choice to use those statutory defences. And when I first started reading about this and doing research about it, I became outraged and I could not let it go. The deeper I dug, the more injustice I found. And so I started to do research about it, I started to publish about it, and I started to engage in law reform advocacy about it. And I've been doing that on and off ever since for most of the last 20 years. And I've gradually expanded into other dimensions of child sexual abuse prevention and other child maltreatment prevention as well and response, but with a focus on child sexual abuse. So I've looked at this from legal perspectives, ethical perspectives, and social science perspectives. And we've got a long way to go, even in places like America and Australia, and we've got further to go in the rest of the world, believe me. However, having said that, I do come to you today with some glimmers of hope from down under. So we've had this enormous and extremely impressive Royal Commission, which wound up and delivered its final report in December last year, so about 4 months ago. And this Royal Commission is the single largest and most significant public inquiry of its kind ever undertaken in Australia. It was a major investment in social justice and reform of law, policy and practice and institutional prevention endeavours to not necessarily bring an end, but to make sure that institutions did a much better job of preventing and responding appropriately to cases of child sexual abuse. So I am proud to say that Australia and its Royal Commission did a great job. Now, there's much, much more to be done, and I'm not going to stand here and pretend that everything's going to be okay now that we had a great Royal Commission that did a great job, because the test will be about whether the recommendations of the Commission will be implemented soundly and whether state governments and institutions will continue to have this on their radar from this day forward. Okay, so not everything is fixed yet, but some progress has been made, and I'm here to talk to you about that today, and I'll highlight some of the key reforms that have been made already. So just to give you a little bit of background about our Royal Commission, and Australia, by the way, we're a huge geographical country, roughly the same size as the States, maybe a little larger, but we've got a tiny population of 25 million or so, spread over 8 states and territories. But we're kind of the 51st American state. We love all things American. So a lot of us have seen The Keepers and many other much less important series. But this Royal Commission had its genesis in about 2010-11 when there were increasing revelations in the media of scandals, egregious scandals, institutional child sexual abuse on a massive scale and horrendous cover-ups of clear cases of prolific offending, particularly in Catholic Church institutions. Okay, not only the Catholic Church, but particularly. Okay, and I make no apology in saying that. It's simply a fact. Now, there were some significant cases involving extremely high-profile people. I'll mention a couple of them today. I'm not making any imputation as to their personal liability. But you may have heard of Cardinal George Pell. He is the third most senior Catholic in the world. He's essentially, or was essentially, the Vatican's treasurer. At the moment, he himself is being criminally prosecuted for child sex offences. He's the most senior Catholic cleric ever to be charged criminally. There are others in Australia, including archbishops, who have been criminally charged with concealing offences. But Cardinal Pell is currently personally before the courts in Victoria, undergoing a preliminary hearing to see if there's sufficient evidence to take it to trial. So he's been charged himself with committing offences himself. A couple of other names there. Gerald Ridsdale is generally seen as one of, if not the worst, predators in Australian history. He was from the Diocese of Ballarat. Ballarat is generally considered the epicentre of child sexual abuse in Australia. It's a diocese in the state of Victoria. Victoria is a small state, but it's a very powerful state in Australia. Donnelly, that's Kevin Donnelly. There's been books written about this man, one called Hell on the Way to Heaven by Chrissy Foster. I'd heartily recommend that book to you if you're interested. Mulcairns is Ronald Mulcairns. He was an archbishop, again in Ballarat, who was responsible for much of the cover-up. Now, a lot of these scandals were unveiled and investigated over a period of a couple of years by courageous and dedicated investigative journalists. And today, we live in an era where the media is more important than ever. An independent, well-informed and courageous media is incredibly important to democratic society. These investigative journalists helped to uncover these scandals and cover-ups, assisted by courageous police and detectives who did a lot of behind-the-scenes work. They are essential truth-tellers in our societies, and they deserve all the support we can give them. These revelations reached such a point that our then first female Prime Minister, Julia Gillard, announced in November 2012 a royal commission into institutional child sexual abuse. A royal commission in Australian political language is the highest level of public inquiry that can be held. It's incredible. The commission has incredible powers of subpoenas, cross-examination. So they're set up essentially under legislation, and they have very strong powers to compel appearance, provision of documents, and so on. So this was an incredible point in our nation's history, but it also imposed great responsibility on our commissioners. Now, what was significant about this was not only that Prime Minister Gillard instituted this inquiry, but that she made very sure that it had the money and the resources and the personnel to do its job. So she appointed 6 commissioners. 6. 2 of them were former judges, and there were 4 other commissioners as well. Now, in contrast, if we look to the UK today, which is hosting a similar inquiry, there is 1 commissioner. 1. And that commissioner is the 4th one to be appointed to lead that commission. It has been plagued with problems. Okay, so it was very important to get the personnel right at this commission. They were appointed initially for 3.5 years to do their job, and they then got a 1.5-year extension. So they worked for 5 years over 2012 to 17, and they had sufficient finance, about $400 million. Okay, the Australian dollar isn't quite to the same value as the American, but it's still a very substantial amount of money. It was a massive investment in social justice. The purpose was very comprehensive. It was to investigate institutional systems, civil legal systems, criminal legal systems, and other areas of regulation. They wanted to find out what happened and why. Not just cases of clear malfeasance, but just cases where there were systemic problems that could be reformed to help increase the effectiveness of prevention of child sexual abuse. They also had the purposes of engaging in a detailed research program to really draw on the expertise, not just of people in Australia, but people overseas, like some of our speakers today, and like Professor Letourneau, who travelled to Australia to give evidence before the Commission a couple of years ago. So this was a hugely comprehensive and well-resourced endeavour. It was taken extremely seriously indeed. And I am glad to say I think they have done a fantastic job. I did serve as a professorial fellow to the Commission from 2015 to 17, and I did conduct 3 of their research studies for them. Other colleagues of mine worked closely with them as well. So I do know quite a lot about how they conducted themselves, and I think they did an absolutely fantastic job. They had 4 major areas of activity. The first one, and this is not to be downplayed, but first, they listened to survivors. They listened to them, and they learnt from their experiences, and they validated their experiences. They held over 8,000 private sessions with survivors that lasted for at least an hour each, where they just listened to them. They validated their experiences, and they learnt from what the survivors told them about how we can better prevent and respond to child sexual abuse in institutional settings. from those 8,000 and odd sessions alone, about 2,500 matters were referred to police. So the Commission didn't itself have the function of engaging in criminal prosecution, but they could certainly refer matters to police, and they did so in many cases. So that was the first key function that the Commission had. And I've spoken with people who engaged in those sessions, and they found them extremely useful, almost cathartic and healing in many senses, just that aspect of it. So that was incredibly important. The second key activity of the Commission was to engage in deep investigations and to hold institutions accountable. Okay, so I did mention they had very strong powers. They could compel people to appear. So Cardinal Pell was compelled to appear to give evidence. He was compelled to give evidence from Rome. He resisted the requirement to travel from Rome, but they nevertheless were able to use technology to compel his evidence. So subpoenas, powers of examination and cross-examination, they appointed a QC, a Queen's Counsel, a very experienced senior barrister to lead their cross-examinations, and they had a whole legal team. And they had 57 public hearings. Okay, and these weren't just 1 or 2 day long hearings. In some cases, these lasted weeks, and they were streamed live. They had a very deep media engagement. So this was an exercise in public administration and transparency. So the whole nation could witness these examinations occurring. So these involved case studies of particular institutions and individuals, and these were an incredibly important part of the Commission's work. The third key dimension was to conduct a research program. This was to analyse what happened and why, and what needs to happen in different kinds of institutional settings. So religious settings, educational settings, sporting settings, cultural, arts and recreation groups. All of these kinds of institutions were subject to different kinds of research reports. Civil legal problems, criminal system problems, all of these were subject to various kinds of analysis from independent experts, both Australian and overseas. And the final dimension was for the commissioners and their policy team then to analyse all of this evidence and come up with reform recommendations. Okay, and they did this in an incredibly comprehensive way. They released several major reports during the course of the inquiry. So there was an interim report, a working with children criminal history check report, another major report on redress and civil litigation. And then there was the final report, which is 17 volumes, and it stands about that high, almost 5 feet high. It's magisterial. It's huge. Now that won't be enough, okay? The proof will be in the pudding. How much of this is implemented by states and territories in governments and in institutions themselves? But nevertheless, the Royal Commission has done its job. So it's focused on better prevention, better responses to allegations so that cover-ups and inappropriate responses within institutions can no longer happen. It's focused on better treatment, especially of juvenile offenders, and it's focused on reforms to the civil justice system and to the criminal justice system so that responses after the event through legal systems can be more robust and better secure justice. So what were some of the key findings then? So some of these trends I thought would be just worth mentioning today, if only because they differ a little bit from some patterns found in other child sexual abuse settings more generally. So these data come from the individual sessions. So the average age when children were first abused within these institutional settings was 10.4 years of age. Males were slightly older, females slightly younger. Somewhat surprisingly, 63% of survivors were male and 36% were female. So that's a little bit different to what the breakdown is in the general population for child sexual abuse more generally. 85% of survivors said they were abused in institutions by an adult perpetrator. 85%. Again, that's a little higher than in the general community setting. 31.8%, so nearly a third, were abused by a person in religious ministry. Nearly a third of these 8,000 survivors were abused by a person in religious ministry. 20% by a teacher, 13% by a residential care worker, 11% by a foster carer. 85% said they were abused multiple times. Okay, so we're not talking about offending at the lower end of the spectrum here. In addition, 71% experienced non-penetrative contact abuse, but 55% experienced penetrative abuse. 58% said the sexual abuse occurred in a religious organisation, 32% in a government institution, and only 10% in a non-government, non-religious institution. I have to give some more data findings about the Catholic context. Of those abused in a religious organisation, 61% were in a Catholic organisation, and 14.8% Anglican, and the rest were in other denominations. As a proportion of all survivors who had individual hearings, 35% said they experienced sexual abuse in a Catholic institution. The Royal Commission engaged in a detailed analysis of claims that had been made against the Catholic Church authorities in a 35-year period. And this was a conservative analysis because it depended on data where people had not only disclosed their abuse, but they had also made a complaint to a Catholic authority, and that Catholic authority had accepted that complaint and its veracity and had accepted their own responsibility. So 4 huge limiting conditions there, which leads to this conservative analysis. But it analysed these 4,445 claims against Catholic Church authorities from this 35-year time period. There were approximately 2,300 offenders regarding sexual abuse inflicted at some point between 1950 and 2010. And it then compared that data with data about the number of clergy that there were in Catholic Church authorities in that period across the country. So quite complex analysis. But by doing that, it concluded that, again, conservatively, 7% of Catholic priests were admitted by the Church to have offended in Australia in that time period. 7%. And that's a conservative analysis. It did breakdowns by different religious orders. Some of them were as high as 20%. That overall 7% figure is higher than the 4% figure generated by the John Jay study here in the States. So, to some of the good news then. So, some of the key outcomes to date which have flowed in various parts of Australia as a result of recommendations made in reports by the Royal Commission. So I'm just going to focus on 3 just because we're kind of limited in time today. The first one is reforms to civil statutes of limitation. I did make extensive submissions to the Commission about this point. Now, I can note that generally, before these reforms were made, the situation in Australian states and territories was pretty much the same as it is here in the States. Okay, generally, in states and territories, before the reforms were made, if you were sexually abused as a child, you essentially had until age 21 to be able to bring your civil claim. Now, as we know, most kids who are sexually abused, well, many kids who are sexually abused do not ever disclose in their lifetime. Many others who do disclose take years and decades to disclose alone, let alone to be able to institute a civil legal claim. So this very tight time limit is completely inappropriate for this qualitatively different class of case. As well, you have the huge power imbalance that operates in the case of institutional child sexual abuse. As well, the nature of the injuries, the psychological injuries, militate against being able to disclose and bring an action. Post-traumatic stress disorder, you don't want to revisit anything about the events. Dissociative disorders, you may not even remember some of the events until later in life. Okay? As well, many of the injuries don't crystallise until later in adulthood. The extent of your depression and the effect on your employability might not really become apparent until your 30s or 40s. As well, even if you know about your injuries, you might not, make the connection or have the medical advice to help you make the connection until well later in life. Okay, so that very tight time limit is completely inappropriate from a point of view of science and ethics in this context. Now, the Royal Commission accepted all these points, and they, in a report that they published in September 2015, recommended immediate legislative reform in each of the 8 states and territories. And they didn't say, well, let's make it 37, let's make it 45, let's make it 50, or let's have a revival window where people can have, in the next 2 years, they can bring their claim and then we'll just keep the law the same. No. They said, let's remove the statute of limitations for this class of case entirely. There is no time limit for these claims anymore. Thank you. Not only that, they said, we're going to apply this reform, or we want this reform to apply not just from now and into the future, we want it to apply retrospectively to cases that occurred in the past. That was a very, very important finding. They did recommend, and this is, I think, fair, they did recommend that courts retain their powers to stay proceedings if the effect of the lapse of time in the specific circumstances had such a prejudicial effect on the defendant's right to a fair trial that there could not actually be a fair trial. And that's a reasonable protection to retain. Now, a couple of other points before I get to the actual reforms that have been made. The Royal Commission also found that for those who did disclose their abuse in institutions, the average time to do so was 22 years. Okay, so that's just of those who did disclose to anybody, okay, whether they're a romantic partner, whether a friend, whether a counsellor. 22 years, that was the average, and that was just of those who did disclose. And they recognised that non-disclosure and delayed disclosure are influenced by a whole range of factors, both relating to them, their fear, their shame, their guilt, factors related to the offender, the threats and the power imbalance, and factors related at the higher societal level, the taboo and the stigma of being sexually abused at all. Nevertheless, these recommendations, with other reform advocacy efforts, have gradually found their way into state and territory reform bills that have been passed now in 5 of our 8 states and territories. Okay, so in Victoria, New South Wales, Queensland, the Australian Capital Territory, and the Northern Territory, there are now no time limits for civil claims regarding child sexual abuse. In 2 other jurisdictions, Tasmania and Western Australia, there are bills before Parliament, one of which has been passed but has not commenced, one of which is awaiting passage. So there's only one of our 8 states and territories which has not yet had a government reform bill introduced, and that's in South Australia, and I promise you I'm working on that. The second major outcome, which I'll talk about today, is a national redress scheme. Now, this scheme was also recommended by the Royal Commission, It's meant to be a more flexible, less traumatic, more informal method of providing monetary payments and recognition to survivors of institutional sexual abuse. So it's a form of response after the event. It's meant to give people an option other than formal reform through the civil legal system. So it's sometimes called an ex gratia scheme, which means out of grace. Essentially, it's where governments and responsible institutions contribute money towards a central fund to which survivors can apply for monetary compensation. It has three elements. First, a monetary payment to recognise the wrong done. Second, access to counselling services. And third, if the survivor requests it, a direct personal response from the institution. Now, the Royal Commission recommended that this scheme be funded to the tune of $4 billion. They estimated that there would be a potential pool of 60,000 claimants. That's in a country of 25 million people. The Royal Commission actually recommended that the maximum payment permitted under this scheme would be $200,000. The Commonwealth legislation, which is currently before Parliament, has the cap at $150,000 and an average payment of $65,000, and that's not taxable. A couple of other key points about the scheme. A much lower evidentiary threshold applies when you apply to this scheme than would apply if you were in the civil legal system. You need only show that there was a reasonable likelihood that you suffered institutional sexual abuse as a child. Okay, so you don't have to go through the full gamut of gathering all the evidence required for a civil claim. You still need some evidence, but just sufficient to show a reasonable likelihood. So these kinds of schemes are more flexible and speedy, less formal, less costly, less traumatic, and less adversarial than the civil legal system. Now, we should note that these payments are not intended to replicate what you may otherwise be entitled to under the civil system. They are going to be slightly lower than that, okay? But they do offer a quicker recognition financially of the loss that someone has incurred and gives a quicker kind of sense of closure, at least in this sense. We should note that a person who accepts an offer of redress must sign a deed of release, meaning that they will not then sue the institution in the civil system. Now, the good news here is that reform is imminent. However, we're still waiting for some states and territories and some institutions to commit financial resources to this scheme. So I'm confident that this will happen. It might just take a little bit longer, but I think it will happen. I think if any institutions do not pony up, then the Commonwealth Government should be the funder of last resort and should make good on any shortfall. Finally, there are now what we call in Australia child safe standards legislation. So these reforms were recommended by the Royal Commission as a form of prevention and early intervention. Okay, the first two reforms were really about responses after the event through the civil legal system and through the Commonwealth Government Redress scheme. This one is more about stopping abuse at its source and intervening at an early stage. And this is much trickier to get right. Much, much trickier. And we'll have to wait and see, to be honest, how this goes in practice. Nevertheless, the legislation and the principles within it are sound, but what we will really wait on is its implementation. Basically, the Commission recommended that every state and territory introduce legislation to require child and youth serving organisations to adopt comprehensive measures to prevent, identify and respond appropriately to allegations of child sexual abuse within its setting. The purposes are to promote the safety of all children, to prevent child abuse and particularly sexual abuse, and importantly, to ensure that allegations of abuse within the institutional setting are properly responded to and are not covered up. Okay, that's what this is really getting at. Victoria, again, has led the way in implementing reform in this context. So in its legislation, and accompanied by a ministerial order, it sets the following standards which apply to child and youth serving organisations in a whole range of sectors: education, early childhood education and care, out-of-home care, health, religious, cultural, sports services and other welfare services. So the whole gamut. And importantly, there is independent external oversight and enforcement by an independent commission called the Commission for Children and Young People. So that commission can actually audit and inspect these organisations to see what they're doing. And if they're not measuring up to the standards under the legislation, they can give them notices to comply. They can even levy penalties. Okay, so that element of independent external oversight is critical. The Commission should also educate child and youth serving organisations to help them promote compliance and to prevent sexual abuse. So generally there's 7 standards there, and these comport with what are generally seen as the required elements of prevention in the social science literature. So strategies to embed an organisational culture of child safety, including through effective leadership arrangements. That's a challenge for some institutions that really play by their own rules. So that's what I'm really going to be turning my attention to in coming years. And yes, I'm talking about the Catholic Church. Standard 2, a child-safe policy or statement of commitment to child safety. Might not sound like much, but that can be important. Standard 3 is really the key one, I feel. A code of conduct, a detailed code of conduct, all the do's and don'ts, all the rules about what can and cannot be done to establish clear expectations for staff and volunteers, appropriate behaviour with children and what is required. Standard 4, screening and supervision, yes, but also training and education and other human resource practices to reduce the risk of child abuse by new and existing personnel. Standard 5, measures to make sure that responses to allegations are robust and transparent to prevent cover-ups. There are other legal reporting duties, incidentally, that go with that standard, so that reports of suspected allegations cannot just be internal to the organisation. They must go to a separate government department, okay, to give them notice of what's happening. Standard 6, other strategies to identify and reduce risks, and Standard 7, strategies to promote the participation and empowerment of children. So we do have 3 of our states and territories that have already implemented this legislation. Obviously there's 5 left, and that needs to happen and fast. Okay, so we'll be keeping an eye on what happens there. In conclusion, I guess I'd like to end on a note of cautious optimism. Lots of terrible things have happened. There will be more. There will be more. It's very hard to eradicate something like this. However, in Australia, the Royal Commission has shone a light on this. It's brought it into the open. It's made it a secret no more. It's helped for there to be substantial reforms to enhance prevention and responses to cases that have happened. And it's made it clear that government has a role and has a duty. It has a public health-based duty to protect the vulnerable, including children, from this public health problem. But we do need to be realistic about the need for strong and sound implementation and independent external oversight. While we might put faith in our institutions to take care of our children, we cannot leave it just to them. That's not necessarily to be insulting to them. It's just that this is a necessary component of a proper, robust response. We also need genuine attitudinal change within individuals and leaders and institutions. Okay, we need better attitudes towards the protection of children. And we need CYSO leadership to be informed by the science. We need them to be motivated by correct ethics and principles of child protection, and we need them to have those dispositions and those levels of knowledge so that they can fulfil their duty towards children. Thank you very much.